Hi, I'm Greg Dell, joined by attorney Alexander Palomara, and we're going to talk about some MetLife disability lawsuit strategies. And Alex, you've handled hundreds, if not thousands, of MetLife disability denials. And in this video, I want to really talk about what it takes to win a MetLife disability lawsuit. So the typical person who's watching this video and contacting us has recently lost their appeal, which is usually required in all MetLife policies that are governed by ERISA. There are some individual disability policies that don't require an appeal, but they're out there trying to learn, what do I do now? And so what is the things that you need to go through when someone contacts you and you're immediately evaluating, can I help this person to win a lawsuit against MetLife?
Well, the question you asked is kind of an odd question. Like, well, how do you win a MetLife lawsuit? And the key to actually winning any lawsuit, whether it's MetLife or any disability insurance company, is the strength of your claim and your claim file is the most important thing. It gives you the best chance of winning your lawsuit. Of course, we can always, win a lawsuit on a technicality or random arguments that we can come up with. But the best thing you can possibly do for an argument, to win any disability insurance claim lawsuit, is by doing a proper application, a proper claim, and a proper appeal. Because we have to realize when the ERISA laws govern your policy, once the insurance company issues a final denial letter, there's no more submitting any other information in support of your claim. So if you forgot to send in some MRIs or some records from one doctor or another doctor, they're never going to be in there. The judge will never consider it. So the first answer to win a MetLife lawsuit is to do a good job with your appeal, do a good job with your claim. So that's the most important thing you'd possibly do.
So that's a very good tip for the person who hasn't been denied and has an appeal. And we've handled thousands of MetLife appeals, and people hire us all the time to do appeals, or people try to do them on their own. But the how to handle a MetLife appeal, totally, we have great videos of that, right, and a totally different animal. So now you have the situation where someone's done their own appeal, or we did their appeal or whatever, but let's not go with we did the appeal. Someone else did their appeal. They're looking out to you for help. What are the important things, and how are you going to evaluate if you can win this MetLife disability lawsuit?
First and foremost, when someone calls me, they've been denied and there's out of appeals. I want to see the initial denial letter and the appeal denial letter. So I want to see what the insurance company believes is their justification for denying this claim. Now, the denial letter has to give you all this information. The denial letter has to give you the arguments that MetLife believes is justified in denying their claim. And in fact, the ERISA law says they can't make additional arguments after the fact during litigation. Now, we had a case going on right now where the attorney for the insurance company is trying to make additional arguments saying, well, the FCE is bad. And it's like, whoa, Judge, they didn't deny it for that reason. So you can't make so everything all their arguments for denying the claim have to be in the denial letter, right? So also they're going to reference any reports they relied upon. So I want to see, did they send you to an independent medical examination? I want to see, did they send your file out for an independent physician consultant review? If so, how many? And what type of doctor or doctors were these people that did the independent consultants reviews? I want to see if they only did internal in-house reviews, or basically their employee doctors did a review, and I want to see what their specialty is as well. There's so much that I want to see from these denial letters. And all I really need is the denial letters to assess whether think we have a fighting chance to win any potential lawsuit. I don't even need the claim file. The claim file, if someone can give me the claim file, it would be the icing on the cake. But sometimes it's too much to go through the claim file before I decide to sign up a case, because it could be thousands of pages. And I know my clients or potential clients want a lawsuit filed as soon as possible, because they've been at this point without any income for at least 6 months, and they're getting pretty dry over there. So I'll file lawsuits just by reviewing the denial letters. I know what I have with the denial letters, and we can go from there. Whether we can win is another question.
So once you get the denial letter and we get a take to say, based upon our experience, we think you have a chance here. We don't know exactly because we need more information, but we don't necessarily want to delay in terms of waiting another 30 days or so to get that claim file. But when we do get the claim file, explain how that is the entire meat, the everything of the lawsuit.
As I said earlier, once the insurance company issues a denial of their appeal, the claim file closes. No more information can go in front of the judge. So every piece of medical documentation that you've submitted or your doctor submitted, every piece of records or reviews that MetLife commissioned for your claim, again, whether it was an IME, independent medical examination, or a consultant's review, all has to be in there. It's a closed file. So when I sign a client up, the first thing I do, the first day, we send out a letter of representation requesting a copy, advising MetLife that we're representing this person, requesting a copy of the claim file. We get the claim file. What do? We break it down. I got to know exactly on what page of that claim file. It could be anywhere. I've seen claim files as short as 300 pages to, 5,000 plus pages.
Yeah.
I got to know on what page everything's at. So we're going to break it down. And we're going to spend a good couple days just breaking down that claim file alone. And I have a cheat sheet that I make so I know exactly on what page the denial letter is, or what page the initial, what page the independent consultant report is. I need to know where these things are because I need to break down those things. Once I realize where everything is, then I go through those the independent consultant's reviews. I want to know what's this guy saying. What's the guy's name, or what's the lady's name, or the doctor's name? What are they saying? What are their arguments? What are they overlooking? They're obviously overlooking something. If my client now is telling me that they're disabled, and the insurance company is telling me they're not, I have to believe my client. If they really are disabled, then the insurance company messed up somewhere, or their doctor is taking some liberties in their review of the medical records.
So what I want to give the global roadmap for people who are saying, what do we really have to prove in this lawsuit? And you have to understand first, it's going to a judge. Okay, number one, it's not going to a jury if you have a group ERISA policy. And so now the judge is going to make a decision. So if you want to really understand this, you got to know, what is the judge's playbook? What are the rules the judge has to follow? And the judge is going to have two different sets of rules depending upon if this policy has what's called a discretionary clause, which means a discretionary clause is a line in the policy which says that MetLife has the right to interpret the terms of the plan and be the payor. So they obviously have an inherent conflict because they're interpreting it and they're payor. So it's in their best interest to deny because they're the payor, but they're supposed to have a fiduciary duty to all of the plan beneficiaries, which is the policyholder. If this discretionary clause is in the policy, then the judge has to apply what's called an arbitrary and capricious standard. If there's no discretionary clause, then the judge can do a de novo review. The de novo review, talking about first, is very simple. That means judge, review the whole record new, like as if you're the only one who ever looked at it. If you think the claimant's disabled, approve benefits. If you think the claimant's not disabled, uphold the denial. Unfortunately, 75% of these claims and states allow for these discretionary reviews, which are pro-insurance company. The judge first has to review the claim, make a determination. Do you think the person's disabled? Yes or no. If you think the person is not disabled, right, then you're done.
Right.
It's over. You agree with the insurance company, uphold the decision. But if you disagree with the insurance company and think that the person is disabled, now, judge, you have to apply this arbitrary and capricious review, which means you have to give deference to the insurance company and determine, did they act reasonably? It becomes, the entire case turns on, did the insurance company act reasonably, in this case, MetLife. And there is thousands of cases that have come from other judges, other federal courts, even as high up as the Supreme Court, talking about what is reasonable standards of review based upon different factual patterns. And the level of expertise, Alex, when you get involved in this case is now presenting to the judge in what is a limitation of 25 to 30 pages in what's called a brief, a document, where you lay out all of your arguments after you pull out all that evidence that you were talking about before, and then all of the arguments about what MetLife did wrong, and applying all the case law that you can from the thousands of cases that are out there and that are coming every day with new decisions to tell the judge, all of these other courts found that this particular behavior was wrong, therefore you need to find that it's wrong. And that is the challenge of what it takes to win a MetLife disability lawsuit. The big challenge is there's no new evidence, so we have to deal with whatever's there, make the best of it. The other thing is that there's often, for every one case that says what they did is wrong, there's another case that says
it's fine.
It was okay. And so this is a crazy legal landscape of finding everything on both sides of the fence for almost all of the positions. And because of that, it cuts both ways. Number one, it can make it hard for a claimant to win their lawsuit because the insurance companies could potentially find cases that support their position. But it also can make the insurance company lose because we can find lots of case law that supports our position and we could win. And so what happens then in that situation, Alex, is you come up with saying, explaining to the claimant, look, I've done everything I can. I've fully evaluated. I've gone through everything. I know all the case law because I've been doing this for a long time. I read new cases every day. Here's your chances of winning. But what do you win, Alex, and what are the potential outcomes once you get to a point where you're going to tell your client, I think we have a 10%, 50%, 100% chance of winning. Here's the potential outcomes. What are they?
So discretionary clauses are terrible, as you're just kind of saying, because it kind of, like you said, arbitrary and capricious standard. If there's a discretionary clause, you have to prove that you're disabled, and also have to meet the arbitrary and capricious standard, proving that the case was arbitrary. The decision by MetLife to deny the claim was arbitrary. Very high standard, but we win those cases. They're more difficult than the de novo reviews. What do you win? Not as much as people think. Some people think that if I win, that means the insurance company has to pay me till that my policy expires, which would be age 65 or 67. Not so, unfortunately. Think about it this way. If you're a 40-year-old person, make a disability insurance claim, your policy can go for another 25, 27 years, but a lot can happen in those 25, 27 years. One, you could die. Two, you could get better. There'd be advancements in medical treatment or procedures or whatever, you can get better. So there's no guarantee that you're going to be disabled for the next 25 years if you're 40 years old, right? So there's no way the judge can award benefits into the future because the judge doesn't know if you're going to die or get better. So theoretically, all the judge can really award you are past due benefits and say, hey, listen, you guys messed up. It's arbitrary and capricious. You guys made an arbitrary and capricious standard decision that was wrong. Put this person back on claim. So now they owe you the back benefits from the time they denied you. Let's say they paid you for 2 years through January of 2022. They'll just say you owe them from January 2022 to the present and send it back to the insurance company. And then from there on out, the insurance company can deny you again, crazy enough, they can deny you a year later. So it's your duty, and if we're representing you, it's our duty to continually prove to the insurance company that my client, that the lawsuit that we won, they still are disabled to this day. So we're always gathering more medical records, always sending our clients to more medical testing or objective testing as much as we can get, seeing their doctors and whatnot, getting it all in the insurance company. Another thing that's crazy though, let's say the insurance company never paid this person any benefits. They applied for benefits, they get denied from the get-go. The case law actually says the judge can't even award benefits. The judge has to remand it back to the insurance company and say, hey, you guys messed up. Take another look at this case. 99% of the time, or maybe 90% of the time, they're going to say, all right, the judge just kind of gave it to us. We better just award benefits and approve this claim. But technically, they can review it again and say, you know what, no, we got more information. We did not get this wrong. We're denying it again.
Then you got to do everything all over again.
It's crazy. The sad part is that the ERISA laws really favor the insurance company. It's a really messed up scenario. They made it harder for the plaintiff, for the claimants to win these lawsuits. Did they do it on purpose? 100% they did it on purpose. But as I mentioned earlier, the key to any claim is the proof. The proof and the appeal, anything you submit is so important because to reach these high standards is very difficult. So I encourage most people to contact us for the appeal. I love doing appeals. My life is appeals and drafting and litigating cases, lawsuits and litigating cases. But if you come to me for an appeal, it gives us a better chance of not only getting you back on claim with the appeal, but making your claim as strong as possible for the potential lawsuit that's coming down the pipeline.
I want to talk a minute, though, about once you've gone through everything and you set it all up, and you did a good job explaining about if you go through a judge's decision that you could either get it remanded back, they evaluate it again, or you go back and you get paid. But more than 95% of federal lawsuits, whether it's against a disability claim or any federal lawsuit, results in a settlement, which can also be considered a win because the matter's over. You're done with MetLife, they're done with you, and they give you a lump sum of money. And that happens in a lot of claims, which is fortunate. We rarely ever have a claim where we don't get some kind of offer from MetLife to get a case resolved. And so, these policies have a finite amount of money. You gave an example of someone who's 40. If they have 25 years left and they have, whatever it is, $50,000 a year, then it's 25 years times 50,000 is over $1 million, and that's what you're owed on this policy. This is not like an auto accident case where we're going to ask the jury for $5 million, and you could end up with $100. No, this is a fine period of time, but in these cases, it's only the back benefits. There's no guarantee for future. Courts are not allowed to award that. So when MetLife in particular in negotiations offers a settlement, it's often years and years of benefits that you then have to make a business decision to say, do I want to take this amount of money, which is several years, not what I was expecting. MetLife thinks you should get nothing, but they're offering this because they realize there's risk. They could lose, you could win. But if you lose, you could also end up with nothing. and you have nothing because you have no policy. So our job as lawyers is to get as much money possible that we can for the claim, whether that's getting you back on claim, whether that's getting you the highest settlement possible. But we will always put you in the position where you will get an offer, and then you can decide, what do you want to do? And we will tell you, this is what we think from our experience of handling thousands and thousands of cases, that you have X percentage of chance to win. That's what it comes down to. So a win is, yes, comes in many forms. Get a verdict, get a settlement offer, have finality, and do whatever you want with your life and be done. Because, you know, it's often, I don't want to call it a crapshoot, but it's one judge who's going to make that determination. And even if the judge finds in your favor, there's an appeal.
Right.
And even with the appeal, a court can reverse, and this stuff goes on for years and years and years. So we will go the distance on every single case, whatever it may be, within reason. If we're telling you, if there's a loser, we're going to tell you, this case has no chance of winning, and you can expose yourself to the defense's attorney's fees, which is high risk. You don't want to come out of this owing $50,000 to $100,000 to the insurance company. That would be bad. That's never happened to us, thankfully. But there are risks in these, but there is a opportunity to get money at the end of the road and potentially win the lawsuit.
Right. And we're going to help the people make the best decision possible for them. We're going to tell them what they need to hear, with the ins and outs. We're going to assess their claim and know whether they have a 10% chance or a 100% chance of winning. There's never a 100% chance, but a great chance of winning the lawsuit. Settlements, like you said, they give clients certainty where there is no certainty. You know you're going to have a certain amount of money. You have to make it work for however long you need to make it work for. Sometimes rolling the dice, if you have a 30% chance of winning and you're turning away good money on the settlement, might be a foolish move to do. But we're going to put our clients' claims in the best light possible. That any settlement is going to be the top dollar that MetLife is going to be willing to offer. We're not going to let them get away with offering, something that's way too low. We're going to push them until they're going to say, there's no more money. This is the max we can possibly give. We're going to keep on pushing them until they say that, and probably push them for a little more beyond that as well if we can. So we're going to get our clients either the best dollar settlement possible, or we're going to go to trial and win that lawsuit for them.
Well, thanks for talking about what it takes to win a MetLife disability lawsuit, and also expectations for people who have a MetLife denial. If you're someone out there with a MetLife long-term disability claim, feel free to reach out to myself, Alex, or any of our team of long-term disability lawyers. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to provide you with a free phone consultation.